Welcome back, Focus Learners, to another explainer. Today, we're taking a really close, entirely impartial look at a piece of legislation that has absolutely ignited both domestic and international debate. We're talking about India's 2026 Foreign Contribution Regulation Act, or the FCRA Amendment Bill. This is a fascinating, complex intersection of national sovereignty, religious freedom, and international law. And we are going to break it all down step by step, relying strictly on the primary sources and the data.
Okay, let's dive right into this. Here is our roadmap for today. We'll start with exactly what the FCRA is, then move into the government's rationale for these changes. From there, we'll look at the Christian opposition, the specific demands coming from the church, and finally, the broader global implications.
So, Section 1, what is the FCRA? Let's get the basics down.
Simply put, the Foreign Contribution Regulation Act is the mandatory legal framework in India that acts as the ultimate gatekeeper for foreign money. It governs exactly how any non-governmental organization, charity, or religious group receives and uses money from outside the country. Bottom line, without an active, valid FCRA legislation, an organization in India literally cannot legally accept a single rupee from abroad.
Now, to really understand this current flashpoint, we have to zoom out and look at the history, because this didn't happen overnight. The FCRA was originally enacted way back in 1976. It got a substantial rewrite in 2010, and then in 2020, the government clamped down with some really stringent operational restrictions, like completely banning the transfer of foreign funds between NGOs. Fast forward to today, 2026. A sweeping new amendment bill has just been introduced in India's lower house of parliament, proposing some massive, fundamental changes to how foreign-funded assets are handled.
But before we even get into those new rules, you have to see this staggering number. Over the last few years, a jaw-dropping 22,498 NGOs have had their FCRA licenses canceled. That leaves only about 14,000 active organizations today. So we're talking about a regulatory crackdown on a massive scale, hitting groups across the entire spectrum, from education initiatives to human rights advocates.
And things get really interesting when you break down that crackdown demographically among faith-based groups. An analysis of Ministry of Home Affairs data from January 2022 revealed a stark disparity. Of the religious category NGOs that lost their status, a whopping 72% were aligned with Christian programs. Hindu-aligned groups were a very distant second at 11%, followed by Muslim-aligned groups at 8.6%. So while the law absolutely applies to everyone on paper, Christian organizations have borne a vastly disproportionate impact. And that directly sets the stage for their fierce opposition to this new 2026 bill.
Which brings us to Section 2, the government's rationale. Why push for these amendments now?
Well, the absolute core of the 2026 framework is the creation of something called a designated authority. Under this new rule, if an NGO's FCRA registration is canceled, surrendered, or even if it just accidentally lapses upon expiry, this newly appointed government body steps in. It takes provisional control of all the organization's foreign-funded assets. And if the NGO doesn't get its registration restored, that control becomes permanent. The government can then manage, transfer, or literally sell those assets for public purposes. The state argues this is just closing a technical gap, making sure assets built with foreign money don't end up in limbo when an NGO loses its legal standing.
But the government's underlying motivation is heavily tied to how foreign funds intersect with religion. They strictly differentiate between permitted and prohibited activities. So things like theological studies, sermons, meditation retreats, or preserving indigenous faiths, those are permitted. But conversion-oriented work or proselytization, absolutely prohibited. Organizations are strictly banned from using foreign money for conversions.
The government's whole thesis is pretty perfectly summed up by the Minister of State for Home Affairs, Nityanand Rai. He stated that action against religious conversion is, quote, necessary to prevent the misuse of foreign funding for activities against national security and public order. So from the government's perspective, this isn't about targeting religion. It's fundamentally about transparency, safeguarding national sovereignty, and stopping foreign actors from funding illicit religious conversions within India.
But of course, there's another side to this. Let's move to Section 3, the Christian opposition, and why they view this as an existential threat.
To really grasp the pushback here, we have to look past the dense legal jargon and see the concrete human reality. Christian groups in India run thousands of schools, rural development centers, and hospitals, and these were often built slowly over generations using a messy mix of local and foreign donations. Under this new bill, if their license lapses, maybe just because of a delayed renewal form, these massive community assets vest entirely in the government authority. The burden is then on the NGO to somehow legally separate the domestically funded bricks from the foreign-funded ones to get their property back. Critics are saying this is practically unworkable.
Human rights activist John Dayal really hit the nail on the head regarding their core fear. He called the bill, quote, expropriation dressed in the language of accountability. The terror for these groups is that a simple administrative failure, like a late filing or a missing detail in a report, could result in the permanent state confiscation of charitable assets that took decades to build.
And this brilliantly illustrates why the legal battle lines are so sharply drawn. Umbrella groups like the Catholic Bishops' Conference of India are arguing this is straight-up unconstitutional. They point to Article 300A, which protects property from arbitrary seizure without a court order, and Articles 25 and 26, which guarantee the right of minorities to actually manage their own religious institutions. They're also raising alarm bells because the bill makes NGO key functionaries personally liable for violations, a reversal of the presumption of innocence. Plus, they argue the ban on proselytization is so dangerously undefined that local authorities could interpret it however they want.
So, what do they want? Section 4, demands from the Church.
Major bodies like the Catholic Bishops' Conference and the National Council of Churches in India haven't just complained, they've actually presented unified, actionable demands to the Home Minister. First and foremost, they want the immediate withdrawal of the 2026 bill to allow for wider stakeholder consultation. They argue that if you need a regulatory framework, fine, but there absolutely must be independent judicial oversight before any assets are seized. It shouldn't just be an executive authority's decision. They're also demanding the law clearly distinguish a minor procedural error from deliberate fraud and that legally acquired assets remain dedicated to the charitable intent of their original donors.
A memorandum from the Catholic Bishops' Conference lays it out clearly. Regulation is necessary, but it must not become excessive control or result in unintended expropriation. They're making it crystal clear they aren't fighting against accountability or transparency. What they oppose is this draconian executive overreach, the idea that the state can effectively nationalize a minority institution without ever stepping foot inside a courtroom.
And this brings us to our final part, Section 5, the global implications, because this is making international ripples.
The international community is definitely watching this closely. U.S. Representative Riley Moore was very explicit, warning that this legislation could damage strategic diplomatic ties. He stated, "This is a clear attack against Christians. If this bill proceeds, it would be a point of major concern in our bilateral relationship with India. We are literally seeing lawmakers abroad pressuring their diplomats to take these concerns directly to New Delhi."
And it's not just foreign politicians. Global financial watchdogs like the Financial Action Task Force have chimed in, issuing warnings that India's FCRA measures risk being over-broadly applied to restrict legitimate civil society. International human rights organizations are echoing this exactly, fearing that under the guise of national security, sweeping regulatory laws are being used to suppress independent, minority-led advocacy and development.
So, to synthesize this entire explainer, it really boils down to three competing narratives. The Indian government's primary focus is national security and sovereignty, and their stated fear is the misuse of foreign funds for forced conversions. Christian NGOs are focused on social welfare and minority rights, and they are terrified of state expropriation and losing grassroots assets built over decades. Meanwhile, global watchdogs are focused on democratic freedoms, fearing an overbroad restriction of civil society. All three of these groups are looking at the exact same law, but assessing the risks in totally fundamentally different ways.
Which leaves us with this final, incredibly provocative question. How does a democracy effectively balance its right to state sovereignty and national security with the fundamental freedoms and property rights of its civil society? It's a remarkably delicate tightrope of international relations, religion, and the law, and honestly, how India handles the 2026 FCRA amendment bill is going to set a massive precedent for years to come.